कर रहा। ऐसे ये जो वो है बार काउंसिल, ये फोटो का कराओ इनसे, जो फोटो आए इनके वो बनवाओ अलग अलग।
Good morning, one and all present here. Welcome to the inauguration ceremony of the second SANKHLA and Associates National Virtual Moot Court Competition. Success is not final. Failure is not fatal. It is the courage to continue that counts. This remark of Winston Churchill captures the mooting essence in a surreal form. It emphasizes the learning and progress that come from both achievements and setbacks, and that character is measured by perseverance. Each argument and rebuttal in mooting shapes your advocacy skills, but in life, it's the guts to keep going that leads to success. On this note, it gives me immense pleasure to welcome everyone at the panel of the inaugural session of the second SANKHLA and Associates National Virtual Moot Court Competition 2023. The amicus curiae proudly asserts its position as an unparalleled legal platform renowned for its remarkable swiftness and efficiency. From its very genesis, the noble pursuit of moot court activities has recited atop the lofty summit, driven by the noble ambition to cultivate and nurture the budding legal intellects, adept and at ease in navigating the intricate tapestry of diverse legal systems and cultures that collectively constitute our interconnected global society. Today, with great pride and exuberance, we embark upon the commencement of the illustrious second edition of the second SANKHLA and Associates National Virtual Moot Court Competition, set to unfold in the year of 2023. Our previous endeavors, which encompassed a multitude of enlightening webinars and enriching workshops, culminated in the resounding success of the inaugural edition of this prestigious competition. As we unveil this new chapter, it is a testament to our unwavering dedication to enhancing the overall experience for participating teams. This competition has garnered the attention of 83 teams from all corners of India, offering a splendid occasion for the participants to cultivate the essential skills necessary for their illustrious advancement in the realm of law. On this note, I would like to move forward to introduce before you all the amicus curiae. Today marks the third year anniversary since the inception of the amicus curiae team platform, and this moot court competition is being held as a gesture of celebration. The amicus curiae is the brainchild of several legal luminaries and eminent personalities across the country and the globe. The amicus curiae is a dream online platform which aims at proliferating knowledge and providing an ingenuous understanding and cognizance of various fields of law to make sure that legal knowledge and experience penetrates to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, the amicus curiae aims at providing valuable contributions to contemporary legal issues and developments in the omnipresent field of law to the masses. The amicus curiae is also registered under the Indian Partnership Act 1932 and Ministry of MSME, Government of India. The amicus curiae is presently the 8th largest legal website in India, we are connected to more than 20,000 law students from across 80 plus law schools in the country. Speaking about and introducing our co-partner, SANKHLA and Associates. SANKHLA and Associates is a global commercial corporate law firm in India. The law firm has top lawyers from India, the UK, and Singapore. I would also like to take this opportunity to introduce our other sponsors for the second edition of the SANKHLA and Associates National Virtual Moot Court Competition, namely the Chambers of Abhinav Mishra, GL Parekh Chambers of Law, Adroit Links, Chambers of Advocate Radhika Singh, and Chambers of Advocate Rishabh Raj. I would like to take this opportunity as well to appreciate and thank all our knowledge and media partners for promoting us and showing their incessant support through the perks and privileges that has been granted to the participating teams. Hence, with an utmost delight and on behalf of the esteemed Amicus Curiae team and the esteemed organizing committee, I extend a warm and cordial welcome to each and every one of you, distinguished participants and guests, to the splendid and highly anticipated second edition of the SANKHLA and Associates National Virtual Moot Court Competition. It is with great pleasure that I, Rayani Bhattacharya, have the honor of presenting before you the brilliant and promising legal prodigies, an exceptional platform to express, debate, and above all, cultivate and flourish in your individual mooting odyssey. The essence of moot court competitions resides within the intricate process as participants acquire a plethora of legal knowledge by immersing themselves profoundly into the realm of jurisprudence. It encompasses the entirety of obligations that a legal practitioner must diligently undertake upon embarking the realm of jurisprudence. The second SANKHLA and Associates National Virtual Moot Court Competition offers a great platform for legal intellects to connect, compete, and have a unique experience. Standing before the opponent team and the judges is definitely thrilling and inspiring. Therefore, with this positive feeling, I would take great honor to call upon Dr. Adarsh C. Agarwala, sir, for the opening remarks. Dr. Adarsh C. Agarwala is President of Supreme Court Bar Association and a dynamic, high-profile lawyer, writer, and social activist. He had the rare distinction of serving as Senior Additional Advocate General of Government of Haryana and Additional Advocate General of Governments of States of Uttar Pradesh, Tamil Nadu, and Punjab, and Special Counsel and Senior Central Government Counsel in the Supreme Court of India. His current involvements include President of International Council of Jurists, London, President of International Commission of Writers, Geneva, Chairman of All India Bar Association, Convener of Indian Council of Jurists, Chairman of India Legal Information Institute, and Secretary General of All India Senior Advocates Association. He has been Executive Council Member and General Council Member of National Law School of India, University, Bangalore, and Governing Council Member of National Law University, Delhi, and Academic Council Member of Chanakya National Law University, Patna. He has been the youngest elected acting chairman and elected vice chairman of Bar Council of India, which is the apex statutory body of lawyers constituted under the Advocates Act 1961. Sir, it's an absolute honor to have you among us, and we can't wait any longer to hear from you. Over to you, sir.
Sir, you are muted.
Thank you, Madam Bhattacharya. I'm delighted that my respected sister, Honorable Ms. Justice Mukta Gupta, is the chief guest of this second SANKHLA Associate National Virtual Moot Court Competition 2023. I'm further delighted that a team of young lawyers and students and teachers of the Amicus Curiae is organizing this national moot court competition with the support of Mr. Kapil Sangla, who is the patron in chief. The organizing of such national moot court competition really gives a boost to the young students who want to become successful lawyers. When we were the students, that time the system of moot court competition was not available. That time the system of internship was also not available. The law subject was the last resort for the students who could not get admission in engineering or medical. They were ultimately compelled to take admission in law colleges. But today I'm happy that first priority for the brilliant student is the law. And today we have so many national law schools. Bar Council of India has set up not only the National Law School, Bangalore, but other national law schools in most of the states. And with the advent of these national law schools, very brilliant students are able to get that admission in those schools, and they are becoming good lawyer not only in corporate law but in our litigation side also. We I'm fully aware that when students are preparing for the moot court competition, they have to work very hard. And I have the opportunity of judging so many international moot court competitions as well as national moot court competition. And I can safely say the students of today's time, they are better than our time, and still they are better than us, although we may be the senior designated counsels, but the art, the, the hard work, the students who are participating in such moot court, they are doing a lot. We are not doing so much hard work because we are being briefed by our other counsel, briefing counsel, and we just put before Lordship like Madam Justice Mukta Gupta. So today, by holding such moot court, we are really giving a training how to become good lawyers. And when I'm judging and when I'm speaking after selecting the candidate, then I also tell the students that on which basis we have given the marks. You have to speak in a manner that the judge can understand. You should not be in a hurry, that you speak very speedily and the judge is not able to understand. If judge will not understand your argument, then how the honorable judge will give you any favorable judgment. So we have to argue in a very, very soft manner. We have not to be aggressive. We should be aware of our facts. We should be also aware about the law. So this law subject is the best subject today. After doing law, you have different opportunities. You can become a judge straightway as a civil judge, and after 7 years of practice, you can become additional district and session judge. And after 10 years of practice, you can become High Court judge, provided you have the age of 45. Then you can become law officer, law officer of Government of India, that is being selected through Indian Legal Service. That is UPSC is holding, and all officers of our Ministry of Law and Justice are the officers taken from Indian Legal Service. You can be law officer in public sector undertaking. You can be legal advisor. You can be now different commissions and tribunals are there. And in this participation itself in moot court, when you are being interviewed by the interview board, that they take cognizance of these your participation And if you have won the prize, that will really add to your resume. So with these remarks, I congratulate every participant of these teams because they got this opportunity to prepare and address before participate in this moot court, which will really good for our not only the students but even the lawyers are also learning from your moot court competition. Thank you very much.
Thank you so much, sir, for sharing your enlightening words of wisdom. I really appreciate your remarks, and I'm sure that the participating teams are thrilled by them as well. Moving on, I would like to take this moment to call upon our guest speaker, Ms. Nivedita Chauhan, to enlighten us with her kind words of wisdom. Nivedita ma'am is the co-founder of the Chambers of Abhinav Mishra. Ma'am holds expertise and has worked rigorously on real estate, corporate, commercial and intellectual property laws over the years. She has been an asset to the Chambers and has managed both legal and administrative aspects of the Chambers with great efficiency. She has worked extensively with a number of startups and advised such companies on various legal and regulatory compliances, and has also assisted in execution of various agreements. Her dedicated and meticulous approach has allowed her to provide able assistance in procurement of several notable judgments. She has organized various legal awareness camps and is an active participant in the promotion of human rights. Thank you, ma'am, for joining us today. Over to you.
Good morning to one and all present here. Thank you, Rayani, for such kind words. And first and foremost, of course, I would like to express my gratitude to the Amicus Curie, Rupam, Banerjee, Rayani, and the entire team of Amicus Curie who have been instrumental in organizing this competition, namely second SANKHLA and Associates National Virtual Moot Court Competition, and inviting me to address the gathering. And of course, your contribution in the legal field is I would like I share gratitude for the opportunity to stand before such eminent legal your ladyship, Justice Mukta Gupta, and Dr. Adisha Gulwala sir, Senior Counsel. And as a relatively junior and a young advocate, I feel incredibly humble and privileged to address a gathering of this stature. And it is indeed an honor to be in the presence of your ladyship and sir, who has actually made significant contribution in the legal profession. Your expertise, wisdom and guidance have been instrumental in shaping the legal landscape of our country. I have gone through the moot court proposition. It is indeed a very robust problem based on criminal laws, addressing the validity of several sections of RPC and UAPA against the Constitution of India. It does raise fundamental questions about freedom of speech, equality, and personal liberty. And it also brings into the focus the role of public interest litigation in challenging the potentially unconstitutional laws. So congratulations to the one who started this moot proposition. As you know that this moot court competition is like a legal battleground where you prepare yourself for the real world challenges. So it's where you learn to think on a feet, to articulate your thoughts with precision and clarity. And most importantly, to stand your ground even when faced with the most daunting opposition and of course the thrilling by the judges. I remember, so most, I've interacted with many says who are actually in the profession and in litigation. They say, no, moot court competitions do not actually work. You know, the real world is different, the real practice is totally different. But that's not actually true, because I remember my early experiences in the court as a young lawyer. I was arguing a case involving a complex property dispute I had prepared my arguments thoroughly, had my facts and precedents at the ready. But as soon as I started, the opposing counsel, relatively senior to me, began interrupting with a barrage of objection. But I held my ground, remembered my moot court days and other debating competitions I had participated in during my college days, and responded to each objection calmly and firmly. So the case ended in my favor. Probably I was strong on merits. That was another aspect. And that day I learned the importance of resilience, a lesson I carry to this day. So in my opinion, participate in competition like these and other such debate competitions, it really boosts your confidence and actually prepare you to face sport in the real life. So, what I'm trying to say here is that, participating in moot court competition is not just about winning or losing. That's about the journey, the skills you acquire, the knowledge you gain, the confidence you build, and the relationship you forge. So it is about challenging yourself, pushing your boundaries, and discovering your potential. Legal practice, I'm talking about the ones who would like to choose litigation as their profession in the future. Of course, there are multiple options. One can become a legal in-house counsel, one can appear for judicial examination, many more. So about legal practice, since I'm into litigation, so it's not merely a profession. And learning. As someone engaged in corporate litigation, as I can attest to multifaceted nature of disputes. It requires a deep understanding of intricate transactions and a comprehensive grasp of the practical aspects surrounding the facts of each case. So corporate litigation demands familiarity with the incidental laws that may have repercussions on the outcome, necessitating continuous study and staying updated on developments in the legal landscape. In conclusion, because this is not the first time I have, I'll be judging the moot court competition. What I'm doing is what artists do. So they focus more on the law. They will cite a lot of case laws. They don't try to cut it with laws. What I'm trying to say, the facts and the law are two independent aspects of the argument. And to make your argument better, you need to connect both of them in a way which even the judge is able to understand. So take this as a journey, take this as a learning, this competition. Give your best, put your best argument. Try to take the grilling by the advocates who actually come from the real practice very seriously. In case you qualify for further rounds, the grilling which you experience in your initial rounds actually help you succeed in your subsequent rounds. So take them very seriously. So being in the field of litigation, again, I would say students who would like to pursue litigation in future, they are required to cultivate confidence, adaptability, and a deep understanding of the law. So moot court competition provide an invaluable platform for honing advocacy skills and preparing students for the challenges of real-world litigation. Engaging in real legal practice, particularly in specialized fields such as corporate litigation, becomes a way of life. So as Dr. Adi Sharma sir has rightly said, even we advocates, we also learn this competition. And your ladyship is also here, that even when we argue for the real court, and judges actually help the advocates in honing their own skills, and sometimes they help when you should argue this way. And it will help you, of course, in an indirect manner. So as an advocate also, I keep on learning from the judges, from the bench, and that is a suggestion I would give to the participants, to keep on learning, keep on, try to grasp the hints which the judges of the competition. Thank you. Lastly, thank you everyone. Thank you, Michael Curie, and all of them who are present in this esteemed gathering. Thank you so much.
sharing your experiences. I really appreciate the time that you've taken out to address our participating teams here. And I'm sure that the listeners have confidence because of your words now. Moving on, I would like to take this moment to call upon Dr. Kapil Sankhla, our patron-in-chief for the second Sankhla and Associates National Virtual Moot Court Competition 2023, to enlighten us with his kind words of wisdom. Dr. Kapil Sankhla, sir, is the current managing partner of Sankhla and Associates, which he established about 20 years ago. He has been practicing since 1999 and has received the 2016 Super Lawyer of the Year award. His background includes expertise in corporate and legal advice, litigation and arbitration, white-collar offenses, employment infrastructure, public policy issues, governance, ethics, and policy. He has been an appointed attorney for several government agencies. His major customers are GAIL, DDA, DSITC, Waqf Board in Chandigarh, Life Insurance, and DJB, Indian Corporation, and various private enterprises like Shriram Life Insurance Business, DHI, India Water, SpiceJet Limited. He has worked for the Ministry of Natural Resources and the General Directorate of Hydrocarbons in several international arbitration proceedings in the UK and against Reliance Petrochem and Cairn, India. Sir, it's an absolute honor to have you among us, and we can't wait any longer to hear from you. Over to you, sir.
Personally, one of you, just Gupta, of course, it was an honor sharing the dais with you. Each and every person who's listening to us, who's taken the time out, the judges, everybody who's adjudicating, and Mr. Rohan for a very elucidated why the young students and listening to you as well. I've been really blessed to be a part of this organization and give our inputs to Amicus in whatever ways that we have been able to. This is, I think, third or fourth time that I've been invited by Amicus. This is the second and probably the largest moot court that is going to take place, and I'm pleased to be part of it. First of all, heartfelt gratitude to Amicus and the participants for making it such a huge success. Amicus, I have been associated with now for 2 years. As I said, this is the third or fourth time that I've been invited. This is the second moot court that we are doing with Amicus, and it is an absolute pleasure. As far as I call Amicus, is probably the eighth or the last webs running in India, providing legal knowledge, imparting legal knowledge to young and the established lawyers. I think it is one of the largest portals that is proliferating legal knowledge and providing a base understanding of the laws and the current legal situation as it is going on. On the last Amicus moot court that we had conducted, around 54 to 58 people had participated. I think we have topped that this time. There were national law universities, central universities, Delhi University, Government College, Mumbai, Central University, Kashmir, HIMS, Symbiosis, Amity, you name it, these students were all here. More than 25 top law firms had collaborated, 100 chambers of renowned litigants and companies had been associated. The winners and the prize holders were awarded with different perks like paid courses, mentorships. Competition was promoted in more than 100 law colleges across the country. There was a reach of approximately 1 to 1.5 lakh students as far as I recall. I am very sure that we have topped up this year. As far as moot court is concerned, as Strahan rightly said, it is a stepping stone on understanding what is going to happen. Since I have somewhat of a sense of humor, I was saying this to my youngsters as when you were young, you used to play kachi mitti, you will not get out. You know, when you play these games, it is the same thing. You get a taste of having an acrimonious debate with the vast and smart team called wrong. It might be all theory this time, but the theory is important in itself. You see, in this fast-paced world, advocacy and research skills become paramount important, irrespective of the eye or the technology that you have. The judgments that you can search, getting it out of a book or sitting in the library, you cannot do that by any online search. It might be quick, but it is not the most competent way of looking at the laws and judgments. MOOT competition play a pivotal role in nurturing these skills, encouraging participants to delve deep into legal research and construct well-founded arguments. You might not have that advantage when you're on your legs in your arguing matter. I've been told my voice is breaking. I don't know. I hope that it is better. We have a very fast internet connection in the icon. But do tell me if it is breaking again. Now, the transition that you as young students will have from this virtual code to the real creation is short, intense, and work. You see, once you understand what the MOOT problems is, how to argue for and against, what is the strongest point to put forward, and how to win the heart and the mind of the judge is what is of most importance and is going to bring you up to date on your skills as well. Importantly, what MOOT is going to do is to give you time in which you have to put your best foot forward. And as I said, the arguments are always of twofold. The argument is on law and the argument is to the heart. It depends on the judge and the situation and of course the problem as to what you have to knock first. I remember when I was a young lawyer, I stood up to the court. I wanted to learn from the best. And I was told the best was a gentleman called Mr. Nani Palkhiwala. I think I used to sit in the library and read every book there was pertaining to Mr. Nani Palkhiwala. And there were two things that came to fore. One, they said that he had Ganesha's memory, that he would remember it all. And in the corridors when you would walk and you would give a proposition, he would be in a hurry but ask to join him tomorrow or next day or in the evening. And then, as if magically, he would hear you again and give precedents and judgments and arguments and findings and propositions that no one else could. The second that I remember reading about Sir Nani Palkhiwala was that when he was once arguing a matter, a brother judge whispered in the ear of another judge, "Be careful when you listen, he might mesmerize you." I don't think that there is a bigger compliment that the bench can give to a member of the bar. But there are two things which are of very important stuff. After his death, his brother, who was a research counsel, disclosed a very material fact. He said it took a lot of hard work to make it look easy for Mr. Nani Palkhiwala. What used to happen is, when a position was given to Mr. Nani Palkhiwala, it wasn't as if Goddess Saraswati flowed that the dams of knowledge would open up. What would happen is that he would take the time, go back, look at his notes, tell the proposition to his brother. They would burn the midnight oil, they would prepare well, and the next day, as if it was something that a rabbit has come out of his hat, he would give the proposition to young and not so young members of the party. The second thing as I wanted to say was that I was speaking to somebody who had the good fortune of briefing Mr. Nani Palkhiwala, and I asked him what was it about Nani Palkhiwala that made him what he was. And I was told that Mr. Nani Palkiwala was not just a lawyer or an orator. Mr. Nani Palkiwala was also a great performer. He knew to raise voice, when to quicken this, when to slow it down, when to make about it, when to structure an argument in a way that it would not perhaps be all on binding precedent and law, but would knock the heart of the court. There are various instances, and I would request you young members to read the biographies and the autobiographies of these stars of our profession, to have a deeper and in-depth understanding of the craft of the court. Moot courts give you just that. They give you a taste of the craft of the court, giving time. I remember when I started arguing in Supreme Court for the first time, I was shocked. And my senior told me that, remember Kapil, you will have 15 minutes to win the judge. If he doesn't know your foot, you will have 15 more minutes to go deeper. And you've arrived if you get more than 1 minute. We were used to, and practice started in T. Sazari, which is called the Mother Bar in Delhi. And I was there for 10 months till I was known by my friends to come to High Court. Because in those days, unfortunately, you had to have some kind of backing to be a High Court lawyer. And I was told by my friends that please go to High Court. We have some command over English. We will give you briefs. It took them 6 months after I came to High Court to get the first brief. I think they were waiting for the other to first sit to see whether I would fare well or get out of the court as a fish. And I'm very happy to say that in the years that I have practiced law now, I have practiced not only in our High Court, but in every major court all across India. And as Ms. Chauhan said that she has had the good fortune of judging various courts, I think she will agree with me that when we are judging moot courts, we do find winners. Most of the children, most of the young students who fare well in moot court, irrespective of whether they're winning, give an inkling of how good they go to court, when they stand at the dais, when they're arguing a matter. And it is very important, irrespective of the fact whether you will win or lose, but to know that you have an opportunity and you have to fare well with this opportunity, because somebody somewhere is always watching you, and you don't know when an opportunity is right behind you, going to knock at your door and give you something better. I think a few of our practice. We can see the emerging trends. As I said, we can see AI technology coming to our rescue. But rest assured, as litigating lawyers who go to the court, it would take years for technology to catch up with the fine art of court craft. The technology can help you make your arguments better, find precedents, find judgment, perhaps even give you an inkling of the mind of the court by finding out the number of judgments in your favor or against you by a particular court or a judge. But it still cannot take away the fine art of modulation, the fine art of argument, the fine art of standing in the court, understanding that there are 5 different openers and which opener you're supposed to use to win over the judge, and the conclusion that you're supposed to say before the judge, the court or the bench loses interest in you. Before I conclude, tell you one little story. I remember as a young lawyer in these days, when it only the vacations that youngsters like us who could argue the matters would get an opportunity, because of course T. Sazari was Mother Bar and some eminent lawyers. And I was during vacation sitting in the court in a bail matter, and there was a lawyer by my side, a very senior lawyer, who told me, Kapil, tell me whether, and mine item was item 30 or 31 or something like that. And I went to the court because I had read some lawyer told me that you need to eat the bench to go early and sit in the court to understand how the judges react to different kind of argument, whether you're supposed to deliver it fast or so, law-based or fact-based, etc. And I was sitting in the court, and this lawyer asked me, tell me whether the court will be inclined to give relief in this matter or not. And I perhaps said yes, and he said no, and that was right. This went to some deep matters. This gentleman was bang on. And then I asked him, I said, sir, you have to tell me, how did you know? And he said, listen, you came reading your file and the judgment, because I had a court of judgment of court. And he said, I was sitting here last 3 days rereading the judgment. And he said, every time the judge perhaps slouches, he is disinclined to grant relief. Every time he comes back and sits on chair and relaxed, he's more inclined to grant relief. And this was amazing, because this was a tell that I did not know of. And he was a brilliant judge. My opportunity came, I started arguing the matter. The judge was slouching on his chair, and suddenly he sat erect, relaxed, sat by the chair, and I thought, all right, I have got my bail, and I started concluding. While concluding, he again slouched. And I realized that, the laddu that I was getting is being taken away. Good sense prevailed. I started my argument once again and stopped right in the middle where the judge, I thought, was relaxing. I got free. So in conclusion, remember that MOOT court review, that inkling, that little chance, that nudge of courtcraft, and you're all very fortunate to be here, as we are fortunate to be judging it and to be a part of this. I have confidence in the abilities of each and every participant and of the success of this competition, which I undoubtedly know that it would be a glorious example on how MOOT court should be organized, especially virtually. I extend my best wishes for a productive, intellectually stimulating and memorable event that will leave a lasting impression on everyone who has put party to this. Thank you. Do we also have Justice Gupta here?
Yes, I've already joined since the inception, Mr. SANKHLA. And I was hearing you right now.
I want to tell everyone that I have the deepest regard, as does every criminal lawyer in our High Court. We've looked at law being formulated. We have seen her courtcraft as a lawyer, her impeccable honesty as a prosecutor, and her regard to each and every member while parting. I think it's an honor to the diocese with you, to be here with you. I want to tell you that, I was arguing a matter in the morning, and there was a special public prosecutor who just met me, and he said that, I am jealous that you are going to meet Justice Gupta. I said, no, after this we will go together, and you can probably take some nudges of courtcraft on how to handle yourself and how to stand in the face of adversity. May I just say this, ma'am? That they say that they do not have the physical prowess of a man. They can't work as hard. They say a lot of things, but then someone like you comes and proves them all wrong. Ma'am, you as a lawyer and as a prosecutor, I think, handled some of the most difficult matters of the time. The case that you handled, the CBI matters that you handled. I don't think a normal lawyer even justice remotely to the kind of matters that you handled, and successfully so. Ma'am, as a judge, you authored, I think, approximately, if not more than 200 verdicts, or co-authored them, more than 200 verdicts. And on your last day, I remember this was quite a shock for all of us. On your penultimate day, you showed remarkable judicial progress, staggering 65 judgments on one single day, if I'm not mistaken, ma'am. And in those in most matters, not just 65 judgments, but judgments which are worth their weight in gold. One of the judgments I remember was upholding conviction and a 10-year sentence on 5 Uttar Pradesh police mercenaries. My lord, in this picture of a 26-year-old man. I remember when my lord was elevated and we saw her on the other side of the bar, on the other side. There was somewhat an undercurrent that as a public prosecutor, my lord may probably sway a little towards prosecution, but that was not to be. My lord has been eminently fair and even as a prosecutor. I have to share a story that as a young lawyer, as I said, after 10 years in East Salari, I was pushed to High Court. After around 6 months, I got my first matter, and those all fell matter. I think as a young tadpole of a lawyer, I had appeared in a matter which was a bail matter, where the court had turned towards my lord and asked something, and she was extremely fair about it. So I do remember that not matter what my surname was, what my standing in the bar was, what mattered was that justice was being delivered and was being delivered rightly. I also remember that there was another matter on the same day where my lord had been pleased to commute the death sentence of a man convicted of kidnapping and murdering a 12-year-old boy, emphasizing on the concept of rarest of rare cases, and she being that once again emphasizing the approach that the court should take in case of capital punishment. Everybody knows that my lord has been serving on the court since 2009. She was born in 1961, and may I just say, ma'am, you look very young still, and she is from our campus law center. From in 1983, she of course was at Hindu College, which was very close to my Sri Ram College of Commerce. There was, I think, either rolls or tikkas that were very famous in Hindu College. We would all from SRCC go there en masse. The canteen was much better. She was enrolled at the bar in 1984. She had a diverse practice, but what she is known for and shall always be known for is her expertise in law, and she involved and nurtured the law on the criminal. She became the AP in the High Court in 1993, the Standing Counsel in 2001 for the Delhi government, and has been a giant in the field of criminal law since forever. For example, she appeared in High Court and Supreme Court in various matters, very high-profile matters, like the Jasika Lal murder case, where I had some call in the Sani murder case again, the Niti Katara murder case. As the special counsel for CBI, she was there in the Naval War Room League case, the Priyadarshini Mattu case, and the Madhumita Sharma murder case. You can just imagine the sheer horror of murder cases that my lord has handled as the counsel and as the prosecutor. And as a judge, I am very happy to say that she adjudicated a number of very politically and legally significant and sensitive cases. For example, I do recall the Arnab Goswami case, the defamation case that was there. I think as the special judge in the special court under the Unlawful Activities Prevention Act, she was to examine the students of the Islamic movement of India and whether the same should be declared as lawful association under the Act. She has also adjudicated a number of matters pertaining to freedom of expression, freedom of speech, etc. Wherein in 2020 she directed Google Facebook to remove posts containing allegations of criminal conduct against civil servants by a woman. In another case, she was directed that aimed to provide legal aid to a patient who had tested positive for HIV. But what I would like to emphasize more is not just her life as a lawyer, as a prosecutor, and as a judge, but in a personal capacity. And we are very proud of this man. As in a personal capacity, not only she rehabilitated, after she rehabilitated 300 destitute women and saved them from a life of prostitution, she not only rehabilitated them but also ensured that they get vocation and job. But from a personal capacity and her pocket, got many of them married, and that shows the large heart that ma'am has, not only as a judge but as a human being. I do know that many years back I was asking somebody about what makes a lawyer great, and I remember somebody said that of three or four names that he had taken, including of Justice Sri Lalit, he said that when you see ma'am, you have to remember that she lives a life of, and he had used the word philo, and I said, what does that mean? In the court, she's first in and last out. So that is the dedication to the craft that she has, and I remember this very, very vividly. Also, upon upon her elevation, she had brought immense experience of her knowledge and understanding, not only of law but of human psychology. We now hope to benefit from her expertise as a lawyer, as a prosecutor, as a judge, and now hopefully as a senior lawyer in the Honorable Supreme Court, where I'm very sure that me and many like me would be troubling her and bringing her extremely difficult matters that we know would require and can only be done justice by her expertise. I also hope that she accepts and gives us the opportunities to use her expertise in imparting justice also as an arbitrator. She famously said that in her role as a judge, that granting relief to people is not charity. She said that the judge is not performing any divine duty, and the only effort is to ensure that justice wins in the end. I personally resonate with this view, and also can resonate with the views of my brethren at the bar, that in her watch, justice was not imparted as charity, was not only imparted to the select few but to everyone, fairly and squarely. That justice was protected, that justice won, and that in her current avatar, she will be the custodian of justice, handling matters that will shape the law in the years to come. I thank you, ma'am, for giving us your valuable time and for being a part of our lives. You mean and shall mean a lot to the lawyers, and especially to these young lawyers who I am very sure will turn to you for help and wisdom in times to come. Thank you. Shall we now?
Yeah, should I start?
Yes.
Good morning, everyone. At the outset, let me just first thank Mr. SANKHLA and Amicus Curie for inviting me to this virtual MOOT vote competition. I was amazed when I got to know that there is such a MOOT vote competition, and so many teams, around 80 teams, are participating. But I fondly requested him, when I address children, I want them one-to-one so that they can ask me questions. As a speaker, wherever I go, I believe in speaking less, but letting the children ask me questions, what they want to know from me, which I thought was a better discourse. But today, of course, it will be a monologue. Sometime I'll have the opportunity to have a dialogue with all of you, and I look forward to that. Thank you, Mr. Adish Agarwal. Like an elder brother, you've been always a guiding force to me and my family members. Ms. Vinita Chauhan, Mr. SANKHLA, for all the beautiful words. I do not know whether I deserve them or not, but one thing I know, I have stayed all through what I am in my personal life, what I am inside, I am outside, and there is no dual roles which I play. Dual roles I play is of a professional and a homemaker, that's all, but not personality wise. And I think that is what, if you are a human being, you can sail through every adverse situation, every profession, and that's been my principle from day one. You know, when I joined the profession, I did LLB course, joined LLB course in 1980. Though there were good number of boys and girls who were doing the course, but when it came to joining the legal profession, which primarily meant litigation, there were very few who would come. So this profession at that time was meant for generally the second or the third generation ones, or the first generations who would join as juniors. Come July, you will find so many girls and boys joining the profession after their enrollment, and within 1 year they would fade into oblivion. Some of them joining as law officers to the various banks, PSUs, or trying for judicial services. But litigation, I'm sure, not more than one fourth would be able to survive. It is a very tough profession when it comes to litigation, and till the end you are unsecure because you don't know today you have a client, tomorrow you may not have. So that is the kind of challenge you face every day. You may be the most successful lawyer, but you never know. One day suddenly you find that the breeds have stopped coming. But however over the years, there's been a lot of sea change in this profession and legal studies. At our time, there were hardly, I remember in law college, we had only one moot court. So there were only 3, 4 children who could just get through that moot court and be done. Now you have so many moot courts that almost each child gets an occasion to be a part of the moot. And it is now taken in a very serious manner, almost like a professional course. In fact, it really helps the budding children to find out how to look into the law, how to be thorough with the facts, and then how to present themselves within a limited time. See, we belong to an era where law was not the first choice of profession. It was the last choice. जिसको कहीं नहीं मिला, you go to law. But over the years, this profession has now become a very sought after profession. Firstly, because it is very intellectually stimulating, vibrant, ethical, and a sober profession. And above all, it keeps you connected to the society. In this profession, you meet the downtrodden to the topmost person in the company. And you have to be versatile to be able to handle that person, to see where the problem lies. See, problem is there even with the top brass. Problem is there with the people who are on the roads. Everybody has some other problem. So you need to read what is the problem and where lies the solution. But one reason is it's very stimulating, why this profession is increasing. The second is the growing popularity of this profession is to be greatly contributed to the media also. They highlight some of the matters so much that today every youngster feels that once you become a lawyer, you are a page one person, not even a page three. You are a page one person there. In fact, I used to get so many requests whenever I would be doing some so-called high profile. For me, every matter was the same, but so-called high profile matter, suddenly I would have a spurt of children wanting to join me as juniors. I would say, why? But you're going for your LLM next month. Why do you want to join? The craze to be getting the name into that matter was too much. And I would say, this is unfair to the ones who've been struggling with me all these years. Because of that popularity, to be associated is not the only thing. everybody thinks while studying law and seeing this page one news items daily, they feel they get a very rosy picture that the moment they do law, they'll be able to soon have a big name and lot of money. But let me tell you, Soli Sarabjis and Kali Narimans were not made in one day. They had burnt a lot of midnight oil before they could reach that position. Mr. Adish Agarwal, Mr. Sankla, Ms. Nivedita Chauhan, myself, we all burnt our midnight oil. It doesn't come without a midnight oil. In this profession, the only mantra is no shortcut. You have to work hard, and that's the only way you can go success. Let me tell you my own personal example. As a lawyer, one day I went to the Connaught Place, and I was standing there and looking at the walls over there that I've come to this place after 6 years. For 23 years, I had not seen the sun setting. For the reason you get inside the courtroom in the morning at 9:30, organize for the day, go to the court, come to the chamber and office, do your work, and then by the time you retire home, it's 10, 11, it's already midnight. You don't get to know whether it is summer, it's winter, it's raining. Somebody would say it's raining. Oh, it's raining. You don't even realize that what has happened or how the weathers have changed. So this is the kind of dedication this profession needs. When I joined when I joined this profession as a lawyer in the year 1982, Justice Bhandare said to me that look, even if you go to ask for an adjournment, go prepared with the matter. And I think that is what happened. So everybody knew that the facts of the case would be at the back of my hand. I would be able to guide the judges. Let me tell you, in most of the matters, most of the legal provisions, the judges know. If you are thorough on facts, you can sail through very easily. Only if it is a ticklish proposition or you wanting to develop a proposition that you would like to say that yes, I need to work on it. And this is what Ms. Nivedita Chauhan emphasized, that please be thorough with the facts. What you do is do a lot of research, get all judgments, but will that be applicable or not? I know one day I was doing a matter and the council started with Article 226, the right, the fundamental right. I said, but how is this fundamental right affected there? And where is that ground? He turned the pages, that ground was not there. Now, merely because you've read certain constitutional judgment doesn't mean that they will apply to your case. You can get out with your case even with a simple 2-minute sentence saying, this is the problem and this is why it is hurting. Most of the times, it often happens you hear the lawyer for 15 minutes and you find that he's not making some sense. You call the litigant in forward and just ask him, what is the problem? And he'll tell you in nutshell that this was the problem. And then you know what is because the pleadings, what happens is, he tells something, the lawyer drafts it in a way so that it comes in the framework of the judgments he knows. And when it frames it in that manner, the actual factual background gets lost. And mind you, one single fact can change the application of law. The law which is applicable on a particular fact, the small change in factual situation, the law may not be applicable. And that is why you often say, we see judgments on both sides of the Supreme Court and High Court. That's because there is a small change in the facts. And I have yet to come across a matter where actually both the matters are same. And that's why the law changes. today I find the number of girls, and I'm really encouraged by it, that number of girls are today taking up this profession, and girls like Meghna Sankla, Nivedita Chauhan and all, they are making their way. You know, this is a very demanding profession. When you come, you make it a choice that it is a demanding profession, whether you're a lawyer or you're a general counsel or you are a judge or you are a corporate lawyer, which is now available. It is a very time consuming profession. So one has to be prepared, mentally prepared. If you come that it's a 10 to 5 job, then you are sadly mistaken. Better not to opt, go for some other work. And you know, to develop for every young counsel in this profession, as Mr. Sankla rightly put, when you are a youngster, nobody wants to hand over the case to you. They feel, what if we get the matter is lost? Same thing, a senior counsel will not put too much of effort into it. He'll pay more fees. If it gets dismissed, he won't mind. But if a younger counsel does it, it will be just after that case. It is always on the facts of the case and the law applicable. So it's not that senior counsels don't lose matters and they win matters always, and the juniors always lose the matter. But to develop that faith in the client to be entrusting you with the brief, it is very, very important that when you interact with the client, you are thorough with the legal aspects of it. You know what you are speaking. Gone are the days when, you know, there was a system that the client would say, "Maine to I have to get done from this counsel." Irrespective, there were like family kinships amongst the lawyers and the litigants would continue. Now they are very well aware. They watch the court, they watch their matter, they see what is happening. They are even aware of the legal propositions. So they will come and check whether you are aware, you can deal with the matter confidently. So if you don't know anything, just say, I need to work on this aspect. Don't try to grow big, because that is a very wrong. I've always told youngster, and I think Mr. Sankla also pointed out, you know, in life, it's a long life which we all have. Mostly everybody gets opportunities. But to be able to identify that this is an opportunity, grab it and utilize is very important. I have seen 90% people let go the opportunities which fall in their lap. And 10% who are able to grab, because of lack of hard work, lack of dedication, let go that opportunity. And that is why it is only that one person who grab the opportunity, work hard on it, succeeded. So why I was able to do all these matters? I would never say no to any matter. I would offer others, but everybody felt that, oh, it's a big matter, it will take a lot of time, one doesn't have that energy, one have to work. But I would not say no, I would keep that matter, work hard on it, and do it. Let me tell you, when I became the public prosecutor for the first time on 23rd January 1993, by that time I had not done one criminal matter. I had only done tax and civil. But 2 years down, I was doing murder and cases. Can anybody believe that less than 7 years I was a standing counsel, which is a position akin to the Advocate General of the state? So it is only your hard work which lets you fulfill, takes you where you are. Otherwise, you want to go there, you want to enjoy your life, you have that limit. Now, with the change in economy and societal trends, the present day, it's almost like a big bazaar, a buyer's market, and the client who comes, he feels that you should be a one-stop center for like a big bazaar. Whatever, he will just tell you the problem. This is my problem. Now, whether you file a criminal complaint, whether you file a civil suit, whether you file a writ petition, he is not concerned about it. He says, this is my problem, you have to find out a solution. So it's very necessary for all of you to train yourself into all spheres. Maybe you don't specialize, but if you have the basic knowledge on all the spheres, it really helps. And that is why the advent of law firms or combination of lawyers, where a complete team can look after one client's work, which is in different courts, different tribunals, different forums. One of them would do the criminal, look into the criminal matters, the other into the civil, the third one into the corporate aspects. That's why it is said that you don't grow alone. Learn to grow with everyone. And that's very helpful. Sharing, caring, all this is required in this profession. And be slightly large-hearted, things will be all okay. You get, there was a time when we started the profession. For us, because the senior has given the brief to read and to be able to present in the court was a big thing. We didn't know that there was anything like salary, perks, timings, everything. All you would get a stipend of 300, 400 rupees. And mind you, all at my level had started with this kind of money. And we would be grateful to the senior that he had handed over the brief so that we could study the facts. We've studied the law and all. Problem today is when children out of law college go to a senior, they say, what are your expectations? What will be my working hours? What will be my compensation? So these were things totally unheard of. When you go with a mind that you have to learn like a true shishya, not like a partner that what will be my share in this. Because once you start contributing to that law firm, once you start contributing to that senior, rest assured they would not like to part with you, and they will be giving you adequately, paying you adequately, taking care of you adequately. I've always said that this profession is one where first 5 years you are in a debit balance, your family is to take care. You work hard, 5 to 10 years you can take care of yourself. Just take care of yourselves, and you continue to work hard. 10 years onwards it's plus and plus, that's sky's the limit there. But at no point can your hard work stay. And mind you, it is easy to, but one thing I would like to tell you is, I think Mr. Sankhla also emphasized on it. Today you people all research by putting the keyword and take out the keywords. That's totally different. When you do law or after that start practicing, I would still advise that when you prepare a matter, see, initially no one gets 10 matters a day, so you have one matter in a week or something. Read the AIR manual and the law book on that aspect. You will get to know what is against you, you will get to know what is in your favor, and then only your petition, your defense will be proper. Because your basics will be clear. Today what happens is, you hand over 10 judgments because you've been able to search online, but you've not understood the core of the problem. And see, each judgment, even of the Supreme Court, is given on the peculiar facts of that case. Maybe there is some change, or there is a change in the slight change in the proposition, so it will not apply again. Maybe you get some high court judgment, or maybe you need to read two judgments and then see the impact thereof, how to deal with it. So work on it. Read from the AR manual the relevant section, its pros and cons, its essentials, break down the provision, what are the necessary ingredients thereof. Most of the time, the pleadings do not have the relevant aspects. You know, this profession is very ethical. Some children feel that yes, they can rise very fast by unethical means. Of course, they beg. But I say that they are always seasonal lawyers. If you have to be an all-time lawyer, maintain your ethics, your fairness in the ethics. Mr. Sankla said that I said something as a prosecutor which was fair. You know, once you take that kind of stance, the court has confidence in you. They know that she's read the file. She will not play mischief with anybody. She has no ulterior motives. And that confidence in the court plays a lot. You are unethical in one matter, the court will always have the impression of doubt of it. So maintaining your integrity, ethics, humility, your respect is one of the most essential ingredients when you appear before. Even if you go wrong on facts and law, if you maintain these four aspects, the court will say, okay, we'll help you. Of course, you are a youngster, there is a problem, this is the legal profession, go and read it and comply. See, courts also, the judges, as judges also, we also started as youngsters. We realized what problem we have. We've been all through those problems. It's not that all of us have come from somewhere on the top of the world. We've also grown from the masses, from the grassroots level. And so we know what problems are faced by the children. We need to now thank COVID for at least one thing, the work from home culture, which was earlier totally unknown. Today, at least in your difficult times, especially for women, they can work online, they can do litigations online, and there is so much of work, like you can do drafting, opinions, sitting at home at a period when you are in a lean phase of life, if you want some rest and something. So I think it is upon all of us to encourage this aspect and to help all youngsters in this. The kind of litigation has changed. These days, it's not only in courts, there are a lot of tribunals. Arbitration is one field where there is a lot of people who are having in their commercial contracts arbitration clauses where those strict rules of evidence are not applicable, but by and large it's the CPC and all. But you get avenues, so with the arbitration, your timings are flexible, you can choose according to your choices. So there is, unlike earlier, litigation being the only profession available, today you have in-house counsels and some of them are doing really good. You've got corporates, you've got law firms, big and small size law firms, then you have judicial services, you have litigation also, which is becoming easier with this all technology available to you. So the options are opening up. Academics, I find when you go to NJ, DJ, a lot of children want to go for academics. And they're some of the very, very brilliant ones. Then with global litigation, There is again, you get exposure to do matters which have cross country laws involved, especially high stake matters. There is generally cross country legal issues which you need to deal. So you get a lot of variety to work, which is very stimulating for your brains. With this kind of growth in this profession, I'm sure all of you can create a niche for yourself, find out which aptly suits you, and go forward with it. It's not only that if you become a judge you are successful, or you become a senior lawyer you are successful. There are many ways of attaining success. You know, I think Nivedita said it. When I became a judge, my father told me one thing, that even if somebody is raising a foolish proposition, please listen to it. Law is very dynamic. It changes with what is law? It is the recognition of the societal norms. So what is the demand of society? That is translated into law. With the change of society today, you feel something which is very abnormal, but 10 years down the line, it becomes so normal. And if you had thought of it 10 years earlier, you could be one of the pioneers in it. Would have anybody of us have thought 20 years ago that we'll be sitting online and arguing the matters like this? There is so many things. So it says the most foolish proposition gives rise to the most intelligent legal proposition. And see, some of the judgments of the Supreme Court Constitution Bench, when you raise certain points, don't be hesitant that, oh, people will laugh at me if I say so. Coin it. If you think it is right, coin it. Look into the law for that sense. You will certainly get something. You never know when a good proposition is laid down. Who could have thought that the provisions of the IT Act will be struck down like this? So just think out of the box. Try to find out if there can be any solution. There have been legal issues involved therein. You are bound to succeed. Mr. Sankhla really rightly said that you should be reading the journal. So, of course, we all have our traits. Everybody is a human being. So, as I just now said, that the most unassuming point can be the most sought after. At times, it happens when you go to the court, you feel, oh, this matter is one where you have to get a stay order and notice, and we find that it is dismissed on a very technical point which you never thought of it. That is why the need to read the judgments which are opposite. Because then you can build up your case that this is going to help you out. Here there is a problem and I need to, from my facts, find a solution for this. Mr. Sankhla said about 65 judgments on the last penultimate day. One judgment of which I can never forget. Some people are probably, I think so, intertwined with your life. There is one matter which I disposed of, I don't know the appeal number, it was of one Madhuban. This was her first marriage. She got married to a widower who had 4 children, and the eldest being daughter of her almost her age. And after her marriage, he was working in this Ashok Yatri Nivas, the Ashoka Hotel. There was lots of entrenchment, and she lost the job. So he was doing a finery. Obviously, she started working as a maid. There must be some bickering or something. She was into some kind of mental illness. The problem in our society, we don't recognize mental illness. So one fine day at the home there was a fight, and probably it appears that the elder daughter from the first marriage was cooking. She must be finding something else or something bitter. They had a quarrel, and in that she hit the knife to the girl. When the husband entered in, she hit him. That's what the process is. See, that woman was in jail. So around 15-20 witnesses were recorded when the jail gives a report that she is suffering from mental illness, and it was found to be she was suffering from schizophrenia. And when she was suffering from schizophrenia for some time, the uh, trial was stayed, a medical report started, and when it went to remission, the trial continued. Now, when the appeal came, we wanted to hear the appeal in the first instance, that since they were around 6-7 years she was in custody, but found she was suffering from schizophrenia. You know, long back, as a standing counsel, I had done a matter where for such kind of people, we had sought directions from the High Court that there should be appeals. So this lady was granted bail, but her family didn't come forward to take care of her. Obviously, the in-laws family was no more to look after her, her own family also. Now, since I had done that matter and I knew that there was a direction for short stay home to the Delhi government, the only way out was till schizophrenia could get into remission, you couldn't hear the plea, and how long to keep her in custody like this. So I dug out all that and said, we should notice to the Delhi government that what happened to your halfway homes, the short stay homes. So when all this started, they said we had done nothing. Anyway, there was a continuous mandamus to them in this very appeal of Madhubala, and within 1 year, they were able to have short stay homes. We were shifted to short stay homes. The impact from transfer to jail to short stay home. Before that, we had sent her to an NGO also. Things improved, and then to the short stay home. Was that when this time I sat on the bench, her schizophrenia was into remission again when I called her. And I said, this is the time I can hear her appeal and finish off with her. It was 18 years that woman was inside. Can you read it? I mean, you can understand why it is important to look into these aspects. Nobody highlights it. But as a judge, as a lawyer, you need to look into it. And finally, when I looked into circumstances, one witness said that after the incident, she was sitting quietly outside the gate of her house. So there was some kind of mental problem even at that stage. But at that stage, nobody bothered to get her medically examined. And see the problem that continued for 18 years because of lack of proper legal advice. So you can not only be good lawyers, you can be famous lawyers, but you can help the humanity if you really, really work hard. Devote yourself to the matter. You know, these are some matters which are eye-opener and change the course of your life. You just feel that yes, had some proper assistance, help being given to her at that stage, she wouldn't have languished for 18 years and went into schizophrenia off and on. So, though of course I didn't add any anecdotes into it, if you read that judgment, you will find that entire history of that matter which went on. And finally, I converted her conviction from 302 to 304 Part 1 and released her on the 302. But with a direction that it does not absolve the Delhi government to keep her away from the short stay home because she has no place to go. till she is independent and able to do her things. This, in my mind, is true justice. So when you do a matter, go to the depth of it, try and find out how best you can help the people, how best you can alleviate their problems, and of course, they'll produce a solution. The courts are never rigid. They are always they welcome to all these steps whatsoever. I think with these words, I was just adding up to what was said by Mr. Adish Agarwal, Mr. Sankhla, and Ms. Nivedita Chauhan. Being the last speaker, most of them had already said everything. I just put some or one or two anecdotes into it and try to build it up. My best wishes to all of you for your all future endeavors and also for this book court. May you all win. And let me tell you, till now, whenever I've been going to a book court, the winner would get an internship with me. I can still offer that internship. Anyone who would like to come and join me as an intern is most welcome. Of course, I keep transforming myself. I was a lawyer, I became a judge, but didn't leave the traits of a lawyer. And I will continue to do both the functions again as a lawyer, as an arbitrator. So it's a versatile profession. Be versatile. Be connected with humanity. Be connected with the lives of people. Everybody who comes with a problem, whether he be the doctorants or everybody has a problem, and try to solve it within the legal field. That's the only work. Thank you very much. Thank you all. Thank you.
Thank you so much, ma'am. It was an absolute honor to hear from you, and I mean, to have you amongst us at the same time. I mean, after hearing you, I think most of us present here kind of revisited why we wanted to be in this profession in the first place. And you're definitely one of the most celebrated personalities in the legal field. So thank you so much for taking out time to address our participating teams with your words of motivation. And may I say, ma'am, that it was almost goosebump worthy to have you here. And as such young people, to have you amongst us is beyond imagination. So thank you so much.
I'll be always amongst you, amongst the children. I love going to it. And that's why I said I would love to interact with them whenever I get the opportunity, because this way it's a monologue.
Yeah. Thank you.
Dialogue is always a better one.
We'll make sure it is done soon now.
Yeah.
Yes. Thank you so much, ma'am, and thank you,
Thank
Dr.
you each one of you. Right?
Thank you, ma'am. And thank you, Dr. Kapil Sankhla sir, as well, to be present here and an illustrious address on your behalf as well. It was truly enlightening, instilling confidence in our legally curious minds, including myself. So thank you so much. And on this note, with such inspiring words, I officially open before you all the second edition of the SANKHLA and Associates National Virtual Moot Court Competition. And on this note, on behalf of the Amicus Curiae team, I would like to proceed with the vote of thanks. Today, I'm grateful and enlightened, to be very honest. The keynote address at the second SANKHLA and Associates Virtual Moot Court Competition was really very inspiring. We sincerely thank our distinguished speakers on behalf of the organizing team, the participants, and the attendees as well. Your words have inspired us to explore the legal expertise and advocacy further, and your insights have revealed the complexities of the legal profession and the many opportunities that it offers at the same time. Your ideas, definitely, it was captivating even in a virtual setting. Your ability to simplify complex concepts and then connect with the audience is commendable, and your address emphasized the importance of legal education in shaping the future and the society as well. So we really appreciate the effort you put for coming here and that you shared your knowledge with us. Your dedication to fostering the legal community and mentoring future legal mind is truly admirable. Your words will definitely guide us and the participants in the moot court competition, reminding us of the significance of knowledge and, most importantly, justice. So, thank you for being here and sharing your insights. Thank you for the contribution to making this a successful ceremony. Your address will definitely inspire all the participating teams and all the young legal minds to excel in their legal pursuits. So thank you so much, Justice Mukta Gupta ma'am, Dr. Adish Agarwala sir, Dr. Kapil Sankhla sir, and Nivedita ma'am for guiding us. We are honored to have you here as our inaugural speakers, and we look forward to benefiting from you and your knowledge in the near future. However, we can't forget the minds which are here in the center of this competition. So, to the participating teams, the arduous journey leading to this grand stage has been fraught with challenges and obstacles. It has commanded an unyielding devotion, innumerable hours of scholarly exploration, meticulous groundwork, and an unwavering allegiance to the noble quest for righteousness. Your esteemed presence in this realm serves as a resplendent testament to the indomitable spirit that resides within you, fortified by your tireless endeavors and unyielding faith in the transformative might of the legal system to mold a more sublime and harmonious existence for all. You have exhibited not only your consummate expertise in legal principles, but also your profound capacity to engage in cogent analysis, articulate compelling arguments, and champion the ideals of impartiality and justice that form the very essence of our esteemed legal framework. And most importantly, do keep in mind what our distinguished speakers have spoken about, be it integrity, ethics, hard work, humility. Take this platform as an opportunity to, most importantly, challenge your own self. And on behalf of the Amicus Curie team, I wish everybody best of luck and a very successful event. Thank you so much.
Thank you. Thank you.
Thank you, ma'am. Thank you, sir. Thank you, Adish Agarwala, sir, for being here. Thank you, Nivedita, ma'am, for being here. And thank you to all the participants for joining us.
The participants can now deboard the platform. The meeting. Thank you for joining.